Hi, a quick note before we get started. Minimum Competence now offers CLE courses. Our first course is live and it's completely free. It covers researching federal tax issues after the Supreme Court's decision in Loper, including how the end of Chevron deference changes the way lawyers should approach Treasury regulations, IRS guidance, and tax research more generally. I think it's interesting for a more broad audience, and if you need CLE credit or you're just interested in the topic, head over to cle.minimumcomp.com. Again, the course is free, and you can find it at cle.minimumcomp.com. All right, on to today's episode. Hello and welcome to the Minimum Competence episode for Thursday, August 27th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, a judge weighs whether the Kennedy Center's Trump signage violates his order. Lisa Cook's lawyer says there's no cause to remove her from the Fed. And X loses its First Amendment challenge to New York's hate speech disclosure law. Let's remember, peace cannot be kept by force. It can only be achieved by understanding. And read today's legal news. On this day in legal history, August 27th, 1928, representatives of 15 nations gathered in Paris and signed the Kellogg-Briand Pact, an international agreement in which the signatories solemnly renounced war as an instrument of national policy. Named for U.S. Secretary of State Frank Kellogg and French Foreign Minister Aristide Briand, it was born of the still-fresh horror of World War I and the earnest hope that the great powers could simply agree to stop settling disputes by force. Eventually, 64 nations signed on. It is, on its face, one of the most idealistic documents in the history of international law, and one of the most famous cautionary tales about law's limits. The pact had a fatal flaw. It contained no enforcement mechanism, no sanctions, no army, nothing but the promise itself and the hope that the world opinion would keep nations honest. Within a few years, that hope was in tatters. Japan invaded Manchuria, Italy invaded Ethiopia, Germany rearmed, and the whole edifice collapsed into the Second World War. As a device for preventing war, Kellogg-Briand failed almost completely. And yet, the significance of August 27, 1928 is more complicated than just a noble failure. The pact planted a legal idea that outlived its own impotence, that aggressive law is not just tragic but unlawful. After World War II, that principle became the backbone of the Nuremberg trials, where Nazi leaders were prosecuted for crimes against peace, waging aggressive war, a charge that traced its lineage directly to Kellogg-Briand. So the pact is a genuinely instructive anniversary for lawyers. It's a reminder that a law without an enforcement mechanism is mostly an aspiration, but also that even an unenforced principle can lodge itself in the legal conscience and reappear with teeth decades later. It's worth keeping that dual lesson in mind on a day when we've got stories about whether court orders and legal protections will actually be honored. A federal judge in Washington holds a hearing this afternoon on a question that sounds trivial but is not: whether adding President Trump's name to the Kennedy Center's signage defies a court order. We set this up yesterday. Back in May, Judge Christopher Cooper ordered the Kennedy Center to remove Trump's name from the building, siding with Democratic Congresswoman Joyce Beatty, who sued over the renaming of the memorial to President John F. Kennedy. Then, on August 13th, the center's board, now stacked with Trump appointees, voted to alter the signage to read, "The John F. Kennedy Memorial Center for the Performing Arts, restored and renovated by President Donald J. Trump," and to christen the grounds President Donald J. Trump Plaza. The administration says this complies with the injunction because the building is still technically named for Kennedy. The Trump language is just a donor acknowledgement. Beatty says it's open defiance. Today, Judge Cooper hears them both out. And this is genuinely the crux of the rule of law. An injunction isn't a word game. Courts have long held that you can't evade a court order by finding a technical workaround that accomplishes the very same thing the order forbade. If Cooper concludes the board's maneuver is a bad faith attempt to do indirectly what he directly prohibited, the consequences can escalate toward contempt. The significance, as I noted yesterday, is that this small fight over a plaque is really a test of whether the executive branch treats a court order as a binding command or a puzzle to be solved. And on today's Kellogg-Briand anniversary, it's a pointed reminder that a legal order matters only if it's actually enforced. Now to a fight with far bigger stakes for the economy, the effort to remove Federal Reserve Governor Lisa Cook. Cook's lawyer, Abby Lowell, has sent a letter to the White House declaring there is, quote, "no legally cognizable cause" to fire her, arguing she has never committed mortgage fraud or any intentional wrongdoing. The White House has been trying to oust Cook for over a year, most recently by building a formal process to remove her over allegations that she listed two different properties as her primary residence in mortgage documents, and this comes after the Supreme Court already ruled against an earlier, more summary attempt to fire her. Here's why this is one of the most important legal stories of the year. Federal Reserve governors are not ordinary executive officials who serve at the president's pleasure. Under the Federal Reserve Act, they can only be removed for cause. That phrase is doing enormous work. It traces back to the 1935 Supreme Court decision in Humphrey's Executor, which upheld Congress's power to insulate heads of independent agencies from at-will presidential removal. the legal foundation of the Fed's independence. The current Supreme Court has been chipping away at Humphrey's executor for other agencies, but it has pointedly signaled that the Fed is special and its independence protected. So the battle is being fought on the meaning of cause. Cook's team says a disputed mortgage paperwork allegation with no finding of intentional wrongdoing and no crime doesn't come close to the kind of malfeasance that cause requires. The significance could hardly be larger. If a president can remove a Fed governor he disagrees with by gathering allegations and declaring cause, then the Fed's independence, the firewall that's supposed to keep monetary policy insulated from short-term political pressure, becomes mere fiction. Markets and the rule of law are watching this one closely. And finally, Elon Musk's X has lost its First Amendment challenge to a New York law requiring social media companies to disclose how they handle hate speech. U.S. District Judge John Cronin in Manhattan dismissed the suit and did so with prejudice, meaning X can't refile. The law at issue is New York's Stop Hiding Hate Act, signed by Governor Hochul in late 2024, which requires large social media platforms to disclose their policies for handling hate speech, extremism, harassment, foreign interference, and disinformation, and to report on their efforts. X argued this compelled it to speak, forcing it to make statements about highly sensitive and controversial content under threat of lawsuits and fines in violation of the First Amendment. The judge disagreed, and the legal reasoning is worth understanding. There's a well-established doctrine that governments can require businesses to disclose purely factual and uncontroversial information about their own practices, as long as the requirement is reasonably related to a legitimate government interest. The standard from a case called Zouderer. Judge Cronin found that making X describe its own content moderation policies is exactly that kind of factual disclosure tied to New York's interest in helping users make informed choices about the platforms they choose to use. The significance is that this lands on one side of a genuinely unsettled national fight. Courts have split over social media transparency laws. A similar California law was partly struck down on First Amendment grounds, so this New York ruling, upholding a disclosure mandate, deepens a divide that may ultimately need the Supreme Court to resolve. And there's an irony worth noting. X, the platform that markets itself as the champion of free speech, just lost a free speech case by arguing that being made to describe its own rules violated its rights. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here tomorrow. And until then, remember, power tends to corrupt, and absolute power corrupts absolutely.